All right, good. Good afternoon, good morning, and good evening from wherever you are. Welcome to this session of the East African Law Society webinar. I am Arnold Agava. I chair the East African Law Society's Committee on Air and Space, and I'm pleased to convene this webinar in which we shall discuss aviation blockade occurring on the continent and occurring in other parts of the world. The subject is relevant, timely, and important, hence the need for the East African Law Society to look at what laws are affected and look at ways in which the complexities which have arisen from blockades around the world can be overcome through legal or even non-legal means. I am pleased that today the webinar will be hosted will be moderated by Ms. Brenda Ntihinyura, who is the head of the legal department of East African Community CASOA. She will have a panel of very excellent lawyers, Mr. Jean Bosco Mutangana, who is the managing partner of Mutangana and Partners in Rwanda, Dr. William Kiema, who is a seasoned expert, researcher, and a lecturer on aviation law, and Mr. Francis Okello Abe, solicitor and arbitrator, and is a specialist in dispute management. I would like to hand the floor to Ms. Ntihinyura to take on her moderation powers. Thank you.
Thank you, Arnold. It's a pleasure to be here. Good afternoon, guests, panelists, and participants. It's my pleasure to welcome you all to this panel discussion on air and space blockade of civil aircraft, the law and its implications. Once again, my name is Brenda Ntihinyura, and I'm honored to serve as a moderator of this insightful conversation. So as we all know, this world is highly interconnected. The movement of civil aircraft across national and international airspace is a cornerstone of global commerce, diplomacy, and human mobility. However, the imposition of air and space blockades, whether for political, military, or security reasons, raises complex legal, humanitarian, and economic concerns. These blockades often challenge international aviation law, state sovereignty, and the principles of free navigation. Our discussion today will focus on the legal frameworks governing air and space blockades, the practical implications of such actions, and potential resolutions or reforms necessary to address emerging challenges in aviation security and international relations. So we are privileged to have with us three distinguished panelists who bring extensive expertise in law, arbitration, and international aviation matters. We have Dr. William Kiema, who is a lecturer at Kisii University, with a specialization in aviation law and international legal frameworks governing airspace. We have Mr. Francis Okello, who is a solicitor and arbitration specialist at Francis Mostyn and Company Solicitors, with significant experience in conflict resolution and legal disputes related to civil aviation. And we also have Mr. John Bosco Mutangana, who is a managing partner at Mutangana Partners and is an expert in international law and aviation security policy. So each of our panelists will be bringing their unique perspective to this discussion, and I encourage all of you to actively engage with their insights. Since this is a legal discussion, we need to, understand what frameworks are actually out there that govern the usage of airspace generally. So I'd like to take us to Dr. Kiema. Could you please just take us through what legal instruments govern the blockade of civil aircraft? What gives a state the right to actually block its airspace under international law? And can you take us through how these regulations govern such restrictions?
Thank you so much, Brenda. Just to confirm whether you can hear me and see me. Thank you so much. I think
Yes.
your smile speaks volume of my my presence. Thank you so much. Yes, so when you look or when you talk about the legal framework for air blockage, a number of instruments govern this specific area. One of the most critical one is the Chicago Convention, which we will have a bit of some times to expose it on the major aspects on blockage. But the other international legal frameworks, generally in the arena of public international law, which govern this particular area, particularly some of the treaties include the Vienna Law of Treaties, because of course, we are talking about the interpretation of treaties and the application of treaties. There is also the Law of the Sea Convention. I'll have a very brief occasion to mention how that comes in within the aviation sector. There is also the UN Charter, which is a critical component when it comes to a specific aspect of blockade that I'll be mentioning, which is the no-fly zone. So the most prominent, and of course, customary international law in some of the principles, but the most prominent, and which brings us, because we are in aviation space, when you talk about aviation, you cannot fail Nakata. And the most important public international instrument, please confirm you can hear me. Something tells me my internet is unstable, but if you cannot, somebody just raise your hand. Yeah, so the Chicago Convention, which establishes the International Civil Aviation Authority, is the most important legal instrument that governs the arena of civil aviation. And I'll be mentioning quite a number of key provisions which underpin the Chicago Convention. And one of them is Article 1 of the convention that recognizes, and the key word is recognizes. For those who are aviation historians, particularly from a legal perspective, would actually understand a lot of developments that led to drafting of Article 1 of the convention and the recognition of the principle that will be, I believe, will be deeply entrenched in this particular discourse, the principle of sovereignty of states. And therefore, Article 1 recognized a principle that was already recognized again by the predecessor of the Chicago Convention, which is the Paris Convention, and which had actually arisen from a point of customary international law that recognizes that states have the right to deny you, or states have sovereignty over their airspace. And therefore, that means what Article 1 means that the jure, or by law, you do not, as a state, you do not have a right to go into the airspace. And again, we will talk about a bit the delimitation of airspace, particularly as also provided for under Article 2 of the convention. The states have sovereignty to determine who comes in and comes out. And they have the sovereignty to say that do not fly into our own territory. And because such kind of principle is quite extensive, there are a number of provisions within the conventions which come into place to make sure that civil aviation or the industry is able to go forth. And such provisions include provisions, for instance, in Article 5 on non-scheduled aircraft, Article 6 that also gives states the right to exercise sovereignty on scheduled aircraft system, meaning that you cannot fly to pick up passengers or drop passengers without the permission, which is now governed under Article 6. And Article 6 is what in aviation law we call the Charter of Bilateralism, because it is out of that the bilateral system of trade in air services begins, even though the article itself does not endorse bilateralism way of trading. But because of a lot of history in the arena of circumstances and context, which again, we have no time to discuss what happened in around 1944 and 45, but little guesses of the World War and the infiltration of war and such. And so that Article 6 Article 7, Article 8 talks about the pilotless aircraft, and therefore that is your drones and manned aircraft systems, again, which are still covered by Article 1 in terms of when the convention speaks about no aircraft, it includes the drones, as it were. And Article 9 now goes into specifics under which a state can actually close is airspace. So within the precepts or within the confines of the convention, not so many provisions actually govern the aspect of or provide for instances of closure, because it is not anticipated, but it is not anticipated that nations, a friendly nation, would actually close their airspace as it were. So Article 9 comes in to provide for circumstances on which necessitate countries to close their airspace, and it gives two particular circumstances, which is military necessity and public safety. So when you look at the entire design of the convention and the environment and contextual existence of the Chicago Convention.
Sorry, Dr. Kiema. Dr. Kiema, I beg to.
It is not envisioned that countries will likely close their airspace except in this.
Dr. Kiema, can you hear me?
Outside the convention,
Dr. Kiema,
there exist other mechanisms of closure which are now governed by the UN Charter, which
sorry about that. We seem to have lost him. Dr. Kiema, you're back?
Yes, my apologies. Apologies.
Yes, your bandwidth is low. Maybe you can turn off your video.
Okay.
So that, so we can avoid that. So you can continue. I think we had lost you at the point of the exceptions.
Yes. So
where circumstances where countries close their airspace. If you can.
Yes. Thank you. So so it is only within the context of Article 9 of the convention which enumerates two circumstances and gives conditions under which closure of airspace can actually take place. And this includes military necessity and public safety. And I will give examples in which these circumstances have been invoked. Number one was when there was September 9/11 in the US, when those of some volcanic activities in Europe, there has been closure of airspace based on Article 9. And some of the conditions which must be complied with is that closure must not be, it must be indiscriminate. You must not discriminate one member state and allow another member state to fly. And therefore, it must be also for a certain duration of time and should be issued to all member states. It should be, once you've closed, you should make ICAO, which is the body responsible for management of the convention, of that your airspace is going to be closed, and that from that you'll be able to use what we call NOTAMs, or notice to all airmen, in terms of that closure. So I had gone to the second aspect, which is outside and operate outside the convention in the name of no-fly zone, and which is governed by the UN Charter. Now, under the UN Charter gives states, the UN Security Council rather, the power to close or to impose what we know as a no-fly zone to the territory of any other state, of a state in which there is most humanitarian concerns or issues of war, or as a way of blockade, or actually like punishing that state or inducing compliance to international law to that state. And there's been quite a number of no-fly zones that have been imposed in the past. A good example is what was in Kosovo, in Libya. So they usually arise from that, and it is out of the dissolution of the UN Security Council. And a very good example is what happened in Libya when arising from that resolution, NATO went on to impose a no-fly zone on Libya. So these two exist within that particular confines. And therefore, the key major concern, and going back again to the principal discussion on the Chicago Convention, when you look at a holistic reading of the convention, starting from the preamble, the article that I mentioned, that is Article 1, Article 2, Article 6, Article 5, 6, 7, 8, and 9, and Article 44 on the objectives, you see that the spirit and the letter of the convention is that it does not foresee any other circumstances within the convention under which states party would actually close their airspace unless such the necessity, military necessity and public safety aspect is actually met, and that such closure is actually met in an indiscriminate manner. So the key provision that I've mentioned in terms of the preamble and Article 44, they speak to a very important aspect, because aviation or air transport is so much interwoven with other diplomatic issues. And when diplomatic issues arise, you find that there are quite a number of tools and mechanisms for what is known as coercive diplomacy. And therefore, countries and states, including the UN Security Council, employ various ways of coercing countries to or ensuring that when diplomatic issues arise. And one of the major, air transport being a very critical industry, you will realize that if there is a change in regime and constitutionally, so you find that such change, one of the key institutions that would have any person or throwing a government would actually capture would actually be the airport and the aviation sector. And when the other thing would be, if there's a diplomatic tiff between two nations or more, one of the easily areas of target that is, I would say, misused, or one of the evidence that we are no longer in talking terms, is don't fly into my country, and therefore takes us to the issue of no-fly zones within that. So when you look at these particular provisions of the convention, and particularly provision of the preamble that provide that the purpose of international civil aviation is to engender friendliness between countries, and when also the same theme is actually runs in objectives of Article 44 of the Chicago Convention. And therefore, that means that in terms of the law, countries should not be utilizing or blocking their airspace unless they activate such or unless they invoke the provisions of Article 9 as explained. So what has happened, and I'll give a very a good example, which I think we might have time to discuss later, of a case that went before ICAO Council. Particularly, the case involved Qatar, Saudi Arabia, Egypt, Bahrain, which you find that these countries blocked Qatari Airways because of disagreements, and such decision went to the council and subsequently to the ICJ, and the rule and the law as initiated by these particular bodies has always been that don't use don't block your airspace within the confines unless we are dealing with the issues of military necessity and public safety. Now, if you have to use any other mechanism, then go to the UN Security Council to get a resolution in which the UN Security Council can actually pass a no-fly zone. And then once you implement that no-fly zone, then you'll be within the confines of the law. Thank you, Brenda.
Wow, thank you so much. I think you have adequately given us a basis for this discussion. As lawyers, we always want to know where the law is, what the law says. So you've really taken us through what we needed. Just one thing. I feel like we needed more on the illegal blockades under international law, but I believe you've tried to cover that. But hopefully, at the next discussion, we shall go into it. Mr. Frank, maybe you can now take us through how these air and space blockades that have occurred, that we've experienced, how have they impacted civil aviation operators and passengers?
Thank you very much, Miss Brenda Interior-Manya. And I'll also thank my predecessor for the very, Dr. Kiema, for the very, very in-depth, albeit I think time was a bit limited, introduction into especially the Chicago Convention. One thing that we tend to normally think about when we're flying, we look on that map, whether you're on a plane or you're getting ready, you're parking and getting ready to fly. You look on that map and you sort of build it in your head. I am going to go here, and this is how I'm going to get there. So the first thing is that geographical map in your head. And when you get on the plane, they provide you with the in-flight, information that shows how you're going to fly. So the most significant thing about flights is that airlines have their flight plans. So within that flight plan, you calculate the quickest and the shortest route, and possibly the safest route. So what I would like to discuss at the moment is the most significant event, which is actually a very contemporary event that's taking place in terms of international airspace and blockade. And this in particular is the Russian airspace and the relationship between Russia and the EU. So in 2022, the EU decided under Council resolution to block flights, Russian planes from flying over the EU. This took place in February of 2022 as a result of the current conflict between Russia and Ukraine. That was a council decision of 2022 335 regulation 334. So in that resolution, I said that all Russian operated carriers, including marketing carriers, anything that had a code share, and I hope that the audience appreciate what code share is. Code share is basically a group of airlines get together, and if they can't fulfill their international obligations, they can then either sell it out or hire it out to another airline to take up that route, because getting that slot is normally quite difficult. So if you can get somebody to step in and handle that, you can do that. And airlines that are registered in Russia, airlines that are not registered in Russia but owned, chartered, or otherwise controlled by Russian legal or natural persons. So all these got caught up under this EU Council regulation 2022 334 and 335. What did that actually mean to airlines? That meant that Russia geographically could not then fly their planes into Europe, which is a very significant geographical area. I mean, they border each other. So In response, Russia said, well, if you can do it, we'll also do it, tit for tat. Who then bears the brunt of this decision? Who gets perhaps maybe affected the most? The impact is being felt by Europe. Because if you look at the map of the world, Russia is a vast territory. So all European flights that are traveling across to the Far East have to now avoid Russian airspace, because Russia say if our airlines cannot fly over Europe, likewise we're going to prevent you from flying over Russia. Now, for some of us who are perhaps not, I could probably say, geographically astute, there's something called the airline marketer projection map. The airline marketer projection map says if you're flying from one point to another, what you do, you look at what's called the proximal magnetic pole. So if you are, especially in Europe, if you're in Europe and you're going to Japan, the plane doesn't straight away take off and head off according to your map or what you see on the globe straight across. It goes north first towards the North Pole, and then it goes down. And you ask yourself, why is this the case? Well, it's because you're trying to take the shortest route, and this is the proximal projection map that airlines use. Now, in that proximate projection map, Russia still occupies the vast territory because you're going to have to fly over Russia. So what's happened then is Russia has blocked that airspace and said European flights cannot go over our territory. The Russian Federation reacted, and this has led to a ban of 36 European countries. It should be noted that in practice, this is known as retaliation, and it's not unusual in international law. But let me just go back slightly. There's nothing in law that actually prohibits states, or sorry, that allows states from prohibiting airlines from flying over their territory. There is just a simple case of territorial integrity. What's above you is your space. If I feel unsafe that you're flying over my territory, I have the right to block you. And as Dr. Kema has mentioned, law has been crafted to say, well, that there are certain regulations that we can apply to do this. So what has this led to, and what lessons do we learn from this? Well, the lessons that we learn from this is that, especially us in Africa, and I'll use Uganda, for example. If you're going north, what are your options? Your options are South Sudan, Ethiopia, unless you want to cut across to DRC or go across to the Indian Ocean. But that then adds a huge distance to your travel time. If you want to go south, your options are again DRC or Tanzania. And in terms of airspace blockade, airlines are always looking for efficiency. That's route and fuel. Because without that, they're already struggling as it is. So this has been one of the bugbears of international space challenges. And back to Russia, until recently, this matter has really created an issue with the EU that they've said, right, okay, could we consider renegotiating our relationship with Russia? The fact still remains there are two options. You either negotiate, but how does that then open the airspace and to allow you to safely transcend that airspace? Because historically, we know that planes have either disappeared or been shot down over Russian territory. And this is only very recent. But there's also still the conflict in Ukraine that leaves a lot of issues that pertain. So even if the airspace is open, there's still issues of safety with the errant missiles that have been known to bring down aircraft. So the blockade is something that there are laws that have been crafted to try and reach amicable solutions to. But unfortunately, it's a question of determination as to whether it's safe to do so. So, because once you're over somebody's territory and something happens, it's only a question of degree or their word against yours, what's actually happened to that airline. And it's this I'm talking, especially in relation to commercial flights. We're not talking about conflict-related aerospace interference or interventions like military aircraft. So as we consider this, many of you would have probably taken a flight from Africa to the Middle East. This is in my conclusion. You will notice that there's no airspace blockade over the Yemen, but airlines still try their best to avoid Yemeni airspace, and they normally fly through Saudi Arabia to get to, say, areas like the UAE. And that, again, just adds. I know that I just flew from Uganda to Dubai recently, and that adds 1 hour to your flying time because you've got to get over Saudi Arabia, which is vast territory. So airspace blockade brings a lot of challenges to commercial airlines. And as Dr. Kema mentioned before, there are also geopolitical factors that need to be considered. So that's my little contribution to that particular aspect of it. If you have any questions, I think the moderator will be happy to take them towards the end of this presentation. Thank you very much.
Thank you so much, Mr. Francis. I feel like you've taken us through an entire story of how the entire synergy in the skies works, how countries have blocked their airspace, and I think we have a better perspective on how it actually is. So, Don Bosco Mutangana, could you please now expound more on what has been shared with us by Mr. Francis? Can you expound more on the challenges and the impact on the actual legal framework when it comes to air and space blockage? Can you take us through what you have seen with regard to the challenges?
Thank you, Brenda, and I want to thank the past presentations that have been made, especially taking us through the legal framework and also the practicalities. And thank you so much, Mr. Francis and Dr. William Kema. Let me talk about what I see as implications and of the blockades and also the challenges that are attached to that. First of all, the imposition of an air and space blockade on civil aircraft can have far-reaching implications, both for international relations, but also in the aviation industry itself. Well, on one hand, as Dr. William mentioned about sovereignty, yes, it strengthens the state sovereignty, and the Chicago Convention allows that, especially in Article 1, enabling it to protect its borders from what may be called threats, maybe during periods of conflict. But at the same time, on the other hand, the blockade of civil aircraft can have humanitarian consequences, because civil aircraft carry not only passengers and cargo, but essential goods, medical supplies, food, and maybe immediate evacuations that may be necessary and may be required. So imagine if this situation happens in one country and the other country, and such a kind of intervention is not addressed. So you can imagine, despite the convention that provides for such a sovereignty under circumstances, but this is also something that has to be looked at. So by imposing a blockade, states may disrupt these vital supplies, particularly in conflict zones or areas with humanitarian crisis where they exist. So in addition to that, it affects definitely travelers, grounding flights, stranding citizens of the blocked state or foreign nationals that may need to move out. So it therefore raises questions about the balance between the balance between sovereignty, states' rights to control its airspace, and the broader responsibility to adhere to international human rights standards and rights of the travelers, particularly to the right to freedom of movement, because the imposition of airspace blockade could damage a country's reputation in the international community, despite what the laws and the international conventions provide. So I think you read about the Qatar situation before the ICJ. I'm sure you're aware of that, which I think a number of countries had appealed before the ICJ, and I think Qatar's rights were restored, if I remember that judgment very well. If I'm not, my colleagues will correct me, but I remember that went all to the ICJ. Another point is states that engage in frequent airspace denial could face condemnation. Condemnation may not affect as much, but condemnation or retaliatory actions from other nations doesn't really give a reputation to any nation that does that. You don't need to be condemned for blocking the airspace for civil aircraft and denying people freedom of movement if you are not able to justify the security threat that your country has vis-a-vis the decision that you've taken. So if a state's airspace restrictions are deemed excessive or unjustified, it could face definitely diplomatic and economic consequences, including sanctions or trade restrictions, which definitely might hurt its economy and relations with other countries, because state relations is a fundamental issue before the United Nations and diplomacy, international diplomacy. So we find that as the first part of looking at implications of airspace blockade. But also, when you look at challenges, despite the legal provisions that Dr. William talked about and Mr. Francis, Council Francis, that allows such airspace blockades. But there's a lot of challenges. So lack of, for example, when you look lack of international consensus, how many people believe in such a decision? How is that country, despite its exercise of sovereignty as provided by Article 1 of the Chicago Convention, how is it justified? What kind of threat that if you didn't take such a decision, what kind of threat would you have? Looking at it from a much more broader perspective. So there has to be legitimate reasons for denying access to airspace. While the Chicago Convention allows states to impose restrictions for security reasons, the application of this right can sometimes be controversial. For instance, a state might invoke security concerns to block a civil aircraft, but if those concerns are perceived as unjust or politically motivated, it could lead to disputes among contracting states and international organizations, such as the International Civil Aviation Organization, which has to come in and try to see how to sort out matters that come out of this. So the practical impact on global air travel, because civil aviation, there is that impact, because civil aviation relies on international cooperation and the free movement of aircraft across borders. So an air and space blockade can cause significant disruptions to global trade, as well as passenger transport, as earlier said. So when you look at airlines rerouting, that terminology of rerouting, finding other ways to reroute flights, leading to a higher operational cost, long travel times, passenger inconvenience, to reroute from one direction to the other definitely has a very huge impact. Moreover, such situations, when there are some conflicts and wars, it may be justified But then blockades that has nothing to do with countries of which such a sanction has taken place wouldn't be justified whatsoever. So there has to be any justification to take such a decision, and it has to be in line with ICAO standards. So therefore, the blockade may escalate political tensions, hinder diplomatic efforts, and undermine international agreements that are in place that has to be respected by the contracting parties. So therefore, avoiding such situations, there has to be an illustration of how and when such a decision has to be taken, especially when you look in East African region. I think you read recently in the media that DRC closed the airspace for Rwanda, and Rwanda Air decided to reroute. So when you look at this, is some of the recent development, for example, because in my view, as a Rwandan lawyer, looking at the conventions, looking at the agreements, looking at the ESC partnerships and conventions, such a decision has to meet the standards that are required, as previous speakers have said. So I may for now stop here, and we can proceed. But this is what I wanted to add on what Mr. Francis had said. Thank you, Brenda.
Thank you so much, John Bosco. You've really given us more insight, and we now are made to understand that, I mean, closing the airspace will definitely lead to so many other. It's like a ripple effect. It affects movement of people. It affects people in war zones, transportation of necessary goods, essential goods. There's so many different things that will happen in the global economy as a whole as a result of just closing one single airspace. And we're reminded that much as the principle of sovereignty governs international air law, there is also some sort of exception to this. We need to promote free overflight. ICAO requires states to promote free overflight, and the restrictions are meant to be temporary. The restrictions that are imposed on closing the airspace are meant to be temporary. So where we hear of states closing their airspaces for long durations of time without any timeline, it actually puts us into some sort of disharmony and confusion generally in the aviation world. So now it takes me to what happens. What happens when a state wakes up one day and decides we are closing the airspace towards a particular country? Because again, remember, it has to be non-discriminatory. So what happens when a state feels that they've been discriminated against? Are there any avenues for remedies? Are there any places we can go to seek a solution? So we are going now into dispute resolution. I'm taking us back to Dr. Kiemi. Dr. Kiemi, can you take us through what has been done with regard to dispute resolution in such matters?
Thank you so much, Brenda, and my colleagues. Before I mention dispute resolution, it's good to lay a very background on the nature of this particular industry, and which now will dovetail to issues of dispute resolution. Number one, I think, and you ask a very good question. What happens when you wake up today, your neighbor or another state which enjoys extensive controls a huge airspace, closes their space? So one of the things that you realize about the industry, the aviation industry, is that it's one which is quite ridden with a lot of politics and prestige issues. And it is also one of the areas, and as an area of study of international law, where you find that because of, and arising from that, you find that key terms like aeropolitics, aerodiplomacy have actually arisen because of the use of, or the central place that, or the susceptibility of how airlines are susceptible to be used for diplomatic issues. So when we come to generally on issues of compliance, particularly within the realms of public international aviation law, you find that every state as an incentive to comply with the international principles, particularly the international commercial principles of international aviation law. And there is it's one of the areas where you find extensive harmonization and extensive coordination of all areas of international relations and coordination, because you do not want as a state to adopt bespoke regulations on key aspects on aviation. And then when your neighbor or an airline from Europe is flying to across Africa, there ought to be that element of certainty that as we fly, the regulation, there will be a uniformity in terms of regulations and in terms of the law. And therefore that dovetails to the conversations about compliance and resolution. So you find that international or public international aviation law is unique, particularly when compared to other disciplines of international law, like international trade, particularly in the aspect of dispute resolution. And it is one of the areas where you find a lot of retaliation instead of approaching institutions institutions to actually decide on some of these disputes that arise. And key among them is, first of all, there are likely to be very few, as I said, no country would want to be considered as an outcast, or what we call in diplomacy as a pariah state, in terms of you are behaving uniquely, you're not allowing everybody to fly over your territory, so everybody else is going to close out their airscape. So there's that element of forced compliance with the principles of the convention. And you find that generally in international law, we say that one of the major weaknesses of international law is compliance and enforcement. But international aviation law is an outlier, is an exception, because of this aspect of coordination, the coordination logic around it, which behooves states to behave well so that they can actually participate. Because once you are cut off from flying, that means you are cut off from the global community, as it were. And therefore, you find that because of those particular instances where there are high level of compliance, and because of the aeropolitics and diplomatic issues, the system that arose in terms of dispute resolution mechanism is not as developed as what is equivalent within trade circles, the dispute settlement body and the appellate body and the DCO understanding within the WTO law. So you find that WTO as a forum for trade is a very active forum for dispute resolution. But when we come to the arena of aviation, you rarely find disputes going to entities or bodies of dispute resolution. When you read the convention itself, you also find there's a very, I would say, underdeveloped mechanisms for dispute resolution, considering these aspects of mutuality and such. But there are several avenues that are provided for under the treaty of the Chicago Convention for dispute resolution. And ICAO is given as the body, UN body responsible for international civil aviation, is been given quite a number of mandates. It has a quasi-legislative mandate in terms of the standards and operating the SAPs, standard and recommended practices. It also has a quasi-judicial function in terms that ICAO can actually, or is actually empowered by the treaty to listen to disputes arising from the application of the Chicago Convention. And I will give one of the few, and that's you find that there are not many cases that have actually been adjudicated before ICAO in this particular area, or generally in the area of aviation, because states will either resort to retaliation or countermeasures, as it are within international law, to just impose on compliance with the other states. So one of the few disputes that gives us fodder for discussion today is a dispute that initially intimated, that was actually filed before ICAO, arising from an activity in June 5th, 2017, where 4 countries, Saudi Arabia, UAE, Egypt, and Bahrain, announced cutting of diplomatic ties with Qatar. And therefore, they initiated several unilateral coercive measures on all fronts, making a rapid and unprecedented escalation of tension and hostility between these countries that belong to the Cooperation Council, or the Gulf Cooperation Council. And among the measures that this particular 4 countries adopted, one was actually closing of the airspace. And number 2, a very controversial, well, of course, closing of the airspace itself is controversial, as will be seen from the decision. But also another important aspect, controversial aspect, is that also closure of what we call flight information regions. Now, I'll explain what flight information regions mean in terms of international civil aviation. And that again takes us to the Chicago Convention, and again Article 1 on sovereignty, the scope of sovereignty, or the scope within which states would actually be able to exercise sovereignty is within their territory and their territorial waters. And therefore, part of the legal framework that I initially mentioned was the Law of the Sea Convention, because now we refer to the Law of the Sea Convention to determine, to get to understand in terms of how do states exercise jurisdiction in terms of or what extents, including the zones that have been demarcated, exclusive economic zones, ICs, how do states exercise jurisdiction in this particular area. So you find that Article 1 provides for that sovereignty is to be exercised in the territory of the state, and you find that the airspace of our country is the demarcation of airspace, and this is again another discussion, I think, which the chair of the session will take us in another time about air and space. The demarcation, where does air end, and where does space start? So quite interesting discussion, because up to that point, there is a line known as Kármán's line, beyond which it is considered that the activities on an aircraft will not be supported. And therefore, there is quite a number of discussions and quite a number of theorizing as to, and different opinion between scholars on the starting point between space and the ending point of aviation. But that point, wherever it is, which is extremely very high altitudes, in which actually sometimes you may not even know. As a country, you are within the republic, but you don't know how many aircrafts actually fly, because they are flying in very high altitudes. And if a country X has said you cannot fly, you dare fly, because they might shoot your aircraft down. And that has actually occurred in a number of jurisdictions where you fly. And you find that apart from the Chicago Convention, there are other conventions that actually try to give to pursue a multilateral framework in which countries can actually fly over without permission. One of them is International Air Transit Agreement, which is also known as the Two Freedom Agreement, and which now one of Francis mentioned countries like Russia, countries with expansive airspace have not actually signed such particular agreements, because they sell their rights and they charge you to fly. No matter how high you fly, you should be able to fly. You should be able to ask for permission, or they should be able to, they preserve that right to be able to negotiate other aspects diplomatically, and so that they can actually sell off their right in that particular aspect. So Article 2 extends the jurisdiction, extends to, or it makes reference to exclusive economic zones, in which is brought also the airspace above exclusive economic zones of states are actually considered to be part of the territory of state. And then therefore there's also reference now to the law the law of the sea treaty that takes us to the high seas. Which country has jurisdiction in the area of high seas or the no man's land? So you find that in such areas, since no particular jurisdiction exercises those rights, there are specific rules that have been made pursuant to the annex, which are applicable to those particular key areas. So I went all that long route to come back to explain what flight information regions mean. Flight information regions are basically those specific no man's area where no particular states control. ICAO has given mandate to a number of countries to ensure that there is safe navigation and traffic control in this area. So, and one of the countries that with such responsibility or have been given such a right is actually Bahrain. So, apart from these countries, Bahrain closing its airspace, it also closed a no man's area, and it's also one of the issues that was actually litigated before the court. So this particular blockade took by means or occurred by means of the four states revoking the licenses and operating permits of the national carrier, which is Qatari Airways, and it was done by the issuance of notice to all airmen, and therefore a number of issues were brought before ICAO, and Qatar filed two applications and memorials before International Civil Aviation Organization, which was filed in 30th October 2017 against the blockading states. And in this particular application, Qatar outlined the background to the action against the action was actually against the United Nations Charter, the Vienna Convention of Law of Treaties, the UN Convention on Law of the Sea, Chicago Convention, the International Air Transit Agreement, which I mentioned, the Two Freedom Agreement, and which again I said there's some, which has a very high number of ratification. And I do wish we had a bit of time to would have discussed on how these key instruments, why they exist in terms of the bifurcation that exists between this particular International Air Transit Agreement and another agreement which is now moribund, known as International Air Transport Agreement or the Five Freedom Agreement. So on the ICAO, when the matter was brought before ICAO, the blockading states raised a preliminary objection before the ICAO Council, claiming that the matters before the Council were actually extended beyond the scope of the convention. And number two, that Qatar had actually failed to meet the negotiating requirements before submitting the application. But the ICAO Council basically dismissed this preliminary objection because of some of the rationale which I gave, that under if you are going to issue a blockade don't use it for coercive diplomacy, or don't use it for and because part of what the four blockade states were actually arguing was that this would actually be subject to another dispute resolution forum, for instance, like the ICJ, because it is breaching other conventions and not the Chicago Convention. And therefore, because of that dismissal of the preliminary objection, the four blockading states appealed to the ICJ. Now, and now this takes me back to the convention and the architecture of dispute resolution. So disputes among states are first of all resolved by the council. Then if you are not satisfied by the decision of the council, you can appeal to a tribunal or appeal to the ICJ. And it's quite of a bit of, it's one of the major weaknesses actually of the convention and the entire framework. Very excellent in terms of technical coordination, but when it comes to dispute resolution and the mechanism going around that, it is a bit jumbled up, and it's actually not a strong forum for dispute resolution because of this particular aspect. So arising from that window for appeal, the blockading states appealed to the ICJ. And one of the major issues of appeal was actually that, look, these issues are actually beyond the convention, and they actually arise from lawful countermeasures. Because what they were arguing is that Qatar had breached a number of agreements, a number of which they called Riyadh's agreements. And as a result of that, and we know under international law, you can deploy countermeasures within the conditions that international law have developed for countermeasures. For instance, countermeasures should only be deployed when there is a wrongful conduct. And then there are also issues of ensuring that such countermeasures are actually more reciprocal. Not reciprocal, but they are not exceeding the extent to which a particular state has actually breached a key obligations. And what the court decided again is that, and as we mentioned, for the purposes of blocking within the convention, you only have the window of Article 9, security and safety concerns. Notify everybody, do not discriminate. If you're closing, let it be for reasonable time, communicate, issue notice, notify ICAO and such. But if it is for these other mechanisms, then go to UN Security Council, make your case, and now from that a resolution can actually be passed, so that when you're doing that, you actually you're actually implementing a resolution of the UN Security Council. And therefore, a key aspect that I also mentioned was, and which also discussed within the context of the cases within the Council and the ICJ, is that do not use the aviation industry or the law, the convention and the treaty frowns upon the use of aero diplomacy or coercive diplomacy under international law under that particular case. And therefore, what the states engendered or what wanted to achieve was not actually within the doctrine of countermeasures, and that was actually not the appropriate space to be able to prosecute their matter. And then the other issue that was also before the court, and which Qatar litigated, was the issues of that the aircraft information zones, the FIRs, are actually, it was actually illegal and against the law of the Sea Convention for the block for Bahrain, for instance, to use a no man's land or terra nullius territory for the purposes of imposing a blockade in that particular matter. And going beyond outside and coming back to the African situation or African landscape, there's also been a number of deployment between African countries. And it's a very good example in 1980s and 1990s with most of the African Union, then the Organization of African Unity members, coming together and trying to impose sanctions to South Africa. So we've seen quite a number of very successful and not successful, but deployment of this particular aspect of the convention. And lastly, to mention that arising from this particular dispute of Qatar and the other member states, Qatar Airways was actually estimated to have lost more than $5 billion arising from rescheduling, cancellation, and such. That is it from me, Brenda.
Thank you so much. Just one question. Were they compensated? Was Qatar Airways compensated? You mentioned they had a loss. Were they compensated?
I cannot remember the exact point to know that they are compensated or the mode of compensation that was actually, maybe Arnold would actually mention that particular aspect. But what the court basically did was actually to declare that such closure blockade were actually illegal under international law. And therefore, of course, it is upon now, you see, the issues of compensation, the way compensation works within the arena of international law is different from like civil litigation matters. There are a number of deployments which states can actually choose for the purposes of ensuring enforcement to a decision, and compensation therefore will not even be monetary. So there was no monetary compensation as it were, and as it occurs within trade disputes, because compensation in trade dispute is not the monetary compensation as it were, but the other mechanism that includes legally recognized retaliation measures which a state is given.
Okay, thank you. Mr. Francis, you have your hand up.
Thank you, Chair. I was just going to come in on that question that you asked, Dr. Kema. Retaliation in aerospace or airline business or airspace business is not uncommon. It's not unusual. And when you talk about you asked the question about whether Qatar was compensated. I do recall one of the discussions that was brought up. Qatar did not actually specifically seek any compensation because this is known as under international law. It's acceptable asymmetrical response to airspace blockade. So what you can do, I can do better. Now, what Qatar felt, and it's quite understandable to many of the learned colleagues here, is the principle of economic loss. So how do you then begin to estimate or calculate or compute your economic loss? So it's easy to come up with a figure of, like Dr. Kema said, 5 billion. But how do you then, a very good example is Russia, which I alluded to before. Yes, they do charge airlines for flying over their space, which is, another sort of financial economic generator. It's good for business for, the countries where the airlines fly over. But they look at the cost benefit analysis of that and say, well, I think those airlines actually lose more by not flying over our airspace, because the fundamental objective of airspace blockade is to punish whoever you're directing that punitive action at. And generally, if you prevent an airline from flying over Russia, you're causing all sorts of, issues to the airline. And I think the previous but one commentator did mention, the cost to the airline, the time that it takes to then be able to circumvent or circumnavigate that region. So the principle of economic loss then comes into it. How do you begin to compute that particular loss to a country or to an airline as a result of airspace blockade? That is, again, it goes into the realms of the territories of, where most courts don't have the capacity to be able to. Even small courts find it very difficult to be able to assess damages for economic loss. So international courts, I'm sure, would struggle a great deal with that. That's just the reason why I put up my hand, and I wanted to just come in about that issue, that question.
Okay, thank you very much. I see two questions here. I will just open it to the panelists. You just put your hand up if you're able to answer. So the first is from Mr. Hassan. What is required in circumstances of abrupt incidences in case of war, which has not been initially anticipated? I think I'll just extend on that, where I believe war is actually not always anticipated. And remember, we made reference to the exceptions as to where there can be a legal blockage of the airspace, and there are procedures for that. You notify ICAO, and it's also always a temporary measure, and it's non-discriminatory. So those are the factors that lead to the circumstances of abrupt incidences. But then I'll extend this to the panelists. I see Francis's hand is up. You could take us through what is required in the circumstances where, they're abrupt. There's a war, it has broken up overnight, which is really rare. But yeah, a civil war has broken up. What happens?
Well, I mentioned before that there's no law that governs the, there's no law that specifically permits airlines to fly over another country's airspace. Okay, that's the first thing that we've got to remember. Your airspace has the sovereignty and the territorial integrity that your land space possesses. And we've got to remember that. Okay, so normally when airlines fly over territories, it's by agreement. When you file a flight path, flight plan, you notify that territory that we shall be using your airspace to go. And in fact, I'm not a pilot, but I know that as you approach that airspace, you either send in, a telegram message, or you call in and say, we are entering your airspace, we are exiting your airspace. So what happens then when there is an airspace blockade? Usually airspace blockades arise as a result of hostility. There is hostility that the nation that is imposing that blockade seems to, feels that it's faced by. So safety first, block airspace, because today's wars are usually fought in the air. Airlines or flights going over your airspace tend to have the run of your territory. They've got, they can take whatever images they want of that airspace. So it's not prohibitive that territories protect their airspace from others. So what, in answer to that question, what then happens if that is the case? Well, we've seen the answer to that is that you then fly over somebody else's airspace that permits you to do that. Let me just take you back about 30, 40 years ago. A Korean flight overflew Russian territory, and that flight was brought down. Up to today, they're still seeking compensation over that, but nobody's taken full responsibility about who brought it down. So better safe than sorry. If you think, well, I'll go over your airspace, I think somebody alluded to this before, that flight can be brought down because there's sovereignty over that airspace, and that territory is fully, permitted to take whatever measures it has to be able to prevent anybody from flying over that airspace. So it's a very touchy issue at the moment. And, I go back to the point that I made. Russia's response was by banning 36 countries in Europe from going over its airspace. And that's really hurting Europe. even the vast European Union cannot do anything about that. I hope this answers your question to some extent.
Yeah, I hope it does. Hassan, you can let us know. I've seen Dr. Kiema's hand up, but I believe the next question is also interlinked. So maybe we can go into the next question and then you can answer them both holistically. This is from Mr. Gilbert. My question is concerning how can we link airspace blockage and the concept of necessity and proportionality while considering state practices and usage. Are you able to take on those two? And then I'll also hand over to Jean Bosco when you're done, Dr. Kiema.
Thank you so much, Brenda. I'll combine the two questions, and thank you so much, my colleague Francis. I think you have elucidated on it. Just wanted to add a component of it in terms of war. What happens if war breaks? And as Brenda said, and let me just put out my video. As Brenda said, that war does not abruptly break. But issues of war, of course, will now be, that is what now is provided for under Article 9 and under military necessity. But to answer that question requires to also to understand a critical aspect or even the major contribution to the development of aircraft. That it is thanks to the war, unfortunately, that we have the technology in terms of aircraft, as it were. Before 1918, governments had very little. In fact, flying was experimental. From 1904, you might have read of the Wright brothers. It was quite experimental venture. But now with the outbreak of First World War in 1914, which saw the uptake of or the use of aircraft as instruments of aggression. And before, I think I was just looking at the statistics, that before the war, I think there were less than 2,000 aircraft in Europe. But because of the war, governments expended lavish budgets, which spearheaded military application of the aircraft. And that also speaks the same to World War II. So when you look at the age of development of aircraft was quite squeezed because of the motivation of war. And also that speaks to the extent of even other technologies that have actually arisen. They predominantly, like even the internet, the technologies in space, they are more of military and war-ridden conversations. And therefore, when you look at most of the provisions and reasons why some of the provisions that I've mentioned is because they are actually made with the notion of there's likely to be war at any particular time. And therefore, one of the instruments of aggression would actually be aircraft. And therefore, if there is actually military activity or war, then go under Article 9 and notify everybody. I think Senior Francis mentioned about Yemen. Though, for instance, a country in East Africa may not be in war with Yemen or having any particular problem, but by virtue of that being an active military zone, there's also what are known as ADZs, the areas specifically designated for military activity. Then that brings that particular activity. So there's quite a number of, to date, aircraft and the issues. Part of the reason why sovereignty is the backbone of international aviation law, and that backbone has informed and shaped this particular industry, shaping many different aspects of how even the trade in air services, because of issues of sovereignty,
as an Article 1 and Article 6, where you never hear of multinational airlines. Just like you hear of multinational corporations in banks, you always hear of multinational telecom companies. You never get to hear about multinational airlines because of those key concepts, and even how the conference that resulted to the convention, and the people that actually drafted the convention are actually military men and women, so to speak, informing from that. So there was actually the second question, I believe, was on proportionality and how we get to balance aspects of proportionality within that context, or within the issue of blockade. So as I mentioned, since it is not anticipated that countries would actually use or intertwine issues of aircraft with coercive diplomacy, then proportionality would actually go to the general arena of international law, in which can't, if you, for instance, go to ICJ and you are trying to enforce retaliation and countermeasures, are actually one of the ways in which a mechanism under international law for which you can actually enforce your rights. And you can choose to, if you choose, pursuant to a decision of the ICJ, if you choose to retaliate or cross-retaliate, meaning that you're choosing a different sector, if a country, for instance, has been found culpable by ICJ, and you are conducting a cross-retaliatory, meaning that you're trying to force the other country, either through countermeasures or such, then it will be guided by principles of countermeasures and the principle that inform countermeasures and retaliation, such as proportionality. Therefore, issues of proportionality will likely arise within the general framework. Once you've gone outside the convention and actually you are blocking your airspace as a retaliation measure arising from a decision of the ICJ. That's all from me.
Thank you. Jean Bosco.
Yeah. Thank you, Brenda. Subsequent to what my colleagues have mentioned, one of the participants asked the question of war and how it impacts such kind of blockades. Well, I think in my view, we have to see the nature of the war, because wars under international law are qualified as either international armed conflicts or non-international armed conflicts. And there are certain rules that govern wars, Geneva Conventions, different Geneva Conventions that govern the rules of wars under international humanitarian law. So, but generally speaking, the issues related to aviation are governed by the Chicago Convention, first as the International Civil Aviation Convention of 1944, and domestic or regional rules and laws. So when you look at Article 9, specifically talks about right to establish prohibited areas. That is Article 9 of the Chicago Convention. Establishing prohibited areas within the airspace, which may be used for reasons of military necessity or public safety. And also when you look at the Charter of the United Nations of 1945, particularly Chapter 7, Article 42, it also brings in the aspect of national security and how it impacts that kind of situation. So in my view, there has to be reasons, even when there is war. So is it an international armed conflict that would lead a certain country to create that blockage of a civil aircraft? So there has to be a transparent criteria. While states maintain sovereignty over their airspace, international aviation laws should emphasize transparent criteria for certain decisions, for when airspace restrictions are justified. Because states should be required to consult with international bodies such as ICAO before implementing significant airspace blockades to ensure that such measures are proportionate and in line with international law. Despite that, also, diplomatic dialogue, because it plays a critical role in resolving disputes related to airspace blockades. When states impose blockades for political reasons, dialogue facilitated by international organizations can help ease such tensions, such as ICAO or other regional organizations. The neutral third parties, such as the UN, such as ICAO, could mediate between involved states to ensure that any airspace restrictions do not unduly harm civil aviation or violate international human rights, as earlier presented. So that's why alternative measures has to be sought, such as temporary permission for humanitarian flights in case they are there. But a blockage of a civil aircraft itself raises concerns on aspects of diplomacy, aspects of economy, aspects of right for free movement, aspects of ICAO standards. That's why the issue of the war that was raised by one of the participants has to be addressed in the context of what a war means. Is it an international armed conflict? Is it an international armed conflict, so that countries that are directly involved as an international armed conflict maybe could be banned if they are considered as belligerents to the victim state. So this is really a much more broader aspect that could be discussed. That's why we say that regional agreements, especially in East Africa, could take hand. And African Union, even before looking at the international conventions, there are a number of regional and international conventions that can solve such issues and such problems at hand. So I wanted to say that the imposition of air and space blockades on civil aircraft, while legally permissible by a country that exercises sovereignty, it just poses significant challenges both to international aviation and to the political relations between states. The balance between a state's right, that balance between a state's right to control its airspace and the need for global cooperation in civil aviation is a delicate one. Because while the legal framework under the Chicago Convention itself and other international treaties provide states with the authority to restrict or even deny airspace access, we have to look at the humanitarian and political consequences of such actions. They cannot be overlooked. And the theory of, for example, neighborliness, Pan-Africanism, even before we go beyond all that. So the challenges ranging from political disputes to disruptions in air traffic, they definitely require effective solutions, including strengthened international cooperation. So the war issue raised by one of the participants, in my view, it has to be oriented and defined in the context of international humanitarian law and law governing armed conflicts, because these are international conventions and laws that govern armed conflicts. Any war that breaks up in a country does not automatically allow such a state, despite its right to sovereignty of its airspace, to impose blockade on civilian aircraft. It doesn't, because planes have been flying over countries that are exercising, that are facing armed conflicts, but blockades haven't been put in place as such. So just not to take much time, I think transparent criteria has to be exercised and conventions and regional enforcement mechanisms in place to answer such questions are already in place, and they have to be followed. Thank you, Brenda.
Thank you, Jean Bosco. I think I saw, no, that there was no hand up. There is another question. First of all, we are kind of running out of time, so we need to be as quick as possible. So the next question is, what tools of enforcement are used by states imposing a blockade in case an airline defies the notice of the blockade? I will give this to, I think, Mr. Francis. Maybe you can take this one. Well, I think you had already told us something. You had already hinted on something to this effect, where if there's a notice of blockade and a plane flies over, remember a state is already sovereign, they are likely to shoot it down. So what tools of enforcement are states using? Over to you.
Thank you. So what tools of enforcement are states using to try and deal with blockades. Can I, if I get this wrong, can I just get this right? Are we talking about the enforcing state or the victim state?
I think this looks like it's the state imposing a blockade. So one state wakes up, you are blocked from my airspace, you decide to fly in anyway, what happens? I think that's what I've understood by this question.
Okay. Every right comes with responsibilities. So you've got obligations and responsibilities that have to be governed. So we've already gone over the Chicago Convention. I've also mentioned twice in my submission that there is nothing that prevents a nation from imposing a blockade of its territory, because that's its sovereignty. I think the other matter that we need to also remember is the symmetrical and symmetrical measures and consequences. I did mention before, and I like to focus my discussion on the Russian Federation, because it's not just very topical, it's also contemporary, and it's something that is happening here and now. We do have conflicts taking place all over the world, and we've got blockades and sanctions and counter sanctions taking place. But I think this is probably, in the context of what we are discussing, this is too enormous to overlook. So what measures do states take? So we look at the victim state, obviously, can sort of force or try and negotiate dialogue. And I think diplomacy, dialogue is very, very important, because usually if that fails, then of course there's also the gunboat diplomacy that can be put in place. The laws that govern aerospace, and the Chicago Convention is probably the key piece of legislation here, is they're still very, very raw, and they haven't been really tested as extensively as we would like them to be. ICAO outlines just a framework for international air navigation, but it allows countries to regulate their own space. So again, when you go back to that, the first thing that country will be able to tell you is that, look, ICAO gives us the right to regulate our airspace. What are you complaining about? I did mention before that one of the reasons that lead to airspace blockade is hostility. What are the areas? The most common area of hostility is military, war. But there are other areas like trade, commerce, sanctions and counter-sanctions that take place because of international trade. We're seeing the Americas, an American bloc right now, Canada, all the way down to Latin America, with the US bang in the middle, imposing sanctions and counter-sanctions within this last week. So airspace blockade works almost in a similar vein. Political tensions. During a conflict, a country might close its airspace, and we've seen this happening. We won't mention areas perhaps maybe closer to home, but like I said before, if you know that there's an issue there, even if there's no airspace blockade, you don't go there. Simple as that. It's just common sense. It's the safety concerns. The country might temporarily restrict access, or in some instances say, well, we're not going to do anything, but try and breach our territory if you want. So what are the obligations and the responsibilities? Well, first of all, the humanitarian obligations, the safety of airlines and passengers. These have far-reaching consequences because in the average airline that takes 200-300 passengers, there are multinationals. That brings with it a lot of risks and diplomatic, issues that could arise with that particular airline over your territory, perhaps maybe falling into, into some problems. That means you'll have to deal not just with one person. That's the airline, that the country, the country that the airline comes from, but you're also having to deal with the multitude of passengers that are on that airline. The other thing is also you have to quickly realize how important diplomacy is. Diplomacy. I remember going, at law school. I had a professor who said, "Look, you can tame a swarm of bees more easily with a jar of honey than you could with a jar of vinegar." Because talking, the English say, "Joe, Joe, not war, war." Talking brings about a lot more diplomatic resolutions than war does. War might bring diplomatic resolutions, but with the toll of a lot of lives lost and also financial consequences. So in terms of the enforcing nation, the first, airspace blockade is a very powerful tool. As we've seen, it's extremely powerful. The EU have decided at this point that, look, the best thing to do is try and talk to Russia. 36 countries are suffering. Can you imagine Polish flights heading to Japan have to find another flight path? Polish flights going to Latin America, to Oceania, that's Australia, New Zealand, have to completely find a different flight path. So that creates all sorts of commercial, as we've already discussed this, and financial implications to the airline. So what is the solution to this? What can enforcing states do, and what can the victim states do? Try and find a middle ground, consensus, moratorium, get somebody else to intervene. Like I said, the courts are effective, but as an arbitration, specialist, I know that sometimes litigation, which is my other forte, does not really bring the results that you need. Mediation, ADR, is always one of the most fruitful forms of dispute resolution. So when airspace blockade arises, perhaps maybe you've got other options. You've got ADR, you've got arbitration, and there are several international arbitration specialist bodies that are today available and waiting and willing to appoint mediators and arbitrators to try and resolve disputes between nations. Indeed, I know for a fact that as the standoff and the conflict between Ukraine and Russia is going on, there are diplomatic measures that are being undertaken by the EU to try and resolve, or at least find some kind of moratorium or middle ground. That still won't resolve the bigger issue, because like I keep saying, Russia is a vast territory. And the last thing you want is for your planes to be flying over that vast territory with the history of airlines that have been brought down over that territory in the past 40, 50 years. So you want to try and make sure that if you reach some kind of moratorium or consensus, that is agreed and there's a fundamental and a solid basis to it. And just before I finish, as I speak, I'm speaking from London at the moment. Very often we hear about Royal Air Force jets being scrambled to deal with Russian planes breaching British territory. And look, geographically, it's not that difficult, because the moment these Russian planes go over the North Sea, they're already on the shores of Scotland. So it's not very difficult. So international aerospace is very challenging and a very complex matter. So back to the point that I made, diplomacy is probably the most fruitful, it's a low-hanging fruit that can resolve most of these problems and issues that could possibly arise out of this, out of these conflicts of airspace blockade. I don't know whether I've been able to touch on most of that and address it, but again, Chair, I have sent you a PowerPoint presentation that I prepared for this, so you could have probably upload it, and maybe people can have access to it at the end of this discussion. Thank you.
Thank you so much, Francis. You have really provided extensive insight into how states can enforce blockades or basically resolve them diplomatically. Yeah, so the last question, I know we're out of time. It has been such, I think we need more time next time, but again, concentration spans in the afternoon are quite hard to control. So the last question, do satellites orbiting around the globe follow the same set of rules and laws presented today? This now goes into the realm of space law. I would just quickly say that the regime of international space law governs activities beyond the airspace. So there's a different set of laws. There's a whole UN body responsible for space. So maybe Kasha, yes, Kasha, you can look up on it, and we are free to assist you if you need any further information on that. And at this point, I would like to close this webinar. I'd like to thank our panelists for taking us through what blockages mean, why they exist, when are they legal, when are they illegal, and for helping us actually understand the principles that surround this. So yeah, thank you so much. We greatly appreciate your time. We greatly appreciate all of you attending this session. We are available for any further consultation on the same. We shall share the PowerPoint presentation from Mr. Francis with you. It will provide more insight into what has been discussed today. And yes, let's hope that we do not experience any more illegal blockages for the sake of the East African community, for the sake of Pan-Africanism, especially in Africa, knowing that our aviation space is still very virgin. Having airspace blockages is really self-defeating for purposes of trade and free movement of persons. So we hope to see more lawyers into aviation law, because even in such circumstances, we would be the ones actually spearheading the resolution of such disputes. So yeah, so thank you all very much, and have a great afternoon. I don't know if I'm supposed to hand over to Arnold right now. Maybe I'll hand over to Arnold, but thank you very much for joining this discussion, and have an amazing weekend ahead. Thank you.
The only reason to hand over to Arnold is to thank you, Brenda, for taking us through this panel, expert moderation, and I enjoyed it. I enjoyed listening as a participant of the panel, and learned a lot as well. So I express my deep gratitude to you for organizing the team and for managing everything in the background. And I know you've managed a lot in the background, so thank you very much. And on that note, I bring the panel to an end, and hope to present other panels of the same nature in the future. Thank you.
Thank you very much.
Great. So thank you very much to you all.